various sections. Are you okay with that model, or what are your suggestions? Albert, Rebecca, are you objecting to that mode of discussion? Okay, thanks, Rebecca. Albert, are you okay with that? That we are polishing up ourselves and not
yes, I'm okay. You can just proceed with that.
Sir, thank you. Right away. So these are the questions that were sent by Mr. Stephen Waweru, 2026, and he had retrieved these questions from the course outline. And so briefly, jumping in straight, is that what is civil litigation and how does it differ from civil litigation? What is criminal litigation and how does it differ? So the criminal litigation is the process by which the state investigates, charges, tries, and punishes offenses, while on the other hand, civil litigation resolves private disputes and remedies, where we have damages, injunctions, and declarations. And the anchoring rules is that for criminal litigation, it is a public law enforcement, and prosecution is generally by the DPP, and it is provided under Article 157 of the Constitution of Kenya. While on the other hand, we have civil litigation being private law disputes between parties, and it is governed by Civil Procedure Act. When it comes to the application between the two, is that a standard of proof in the criminal aspect is beyond reasonable doubt, while on the civil side is a balance of probabilities. Okay. Distinguish between substantive criminal law and criminal procedure. Substantive criminal law defines crimes and punishments, while criminal procedure governs how suspects are investigated, charged, tried, and sentenced. We have some anchoring rules where we have substantive laws in the criminal aspect is provided under the Penal Code and Sexual Offences Act, while the procedural aspect is outlined in the Criminal Procedure Code. What are the objectives of the Criminal Procedure Code in criminal procedure in Kenya? The objective is to secure a fair trial, ensure lawful investigation and prosecution, protect rights, and deliver accurate, timely, and just outcomes. The fair trial and due process is provided under Article 50 of the Constitution of Kenya, and bail and liberty safeguards is anchored in the constitutional rights pursuant to Section 123 of the Criminal Procedure Code. Identify the principal statutes governing criminal litigation in Kenya. We have the Constitution of Kenya, we have the Criminal Procedure Code, we have the Evidence Act, we have the Penal Code, and we have various police and investigations framework statutes, for example, the National Police Service Act. We have useful procedural anchors, where plea is provided under Section 207 of the Criminal Procedure Code, revision is provided under Section 364 of the Criminal Procedure Code, and confessions is provided under Section 225 of the Evidence Act. Explain the constitutional principles that underpin criminal litigation under the Constitution of Kenya 2010. And the constitutional principles, we have legality and due process, fair trial guarantees, human dignity and freedom from abuse, torture, inhuman treatment, prosecutorial independence, and we have judicial independence. Those are the principles that have also been outlined in the criminal bench book. Then you go to topic number 2 on jurisdiction and structure of courts. Explain the criminal jurisdiction of the magistrate court, and the answer is that the magistrate court exercises original criminal jurisdiction over offences triable by subordinate courts, subject to statutory limits on sentencing powers and any offence reserved to the High Court by law. And amongst the offences that have been reserved to the High Court, we have crimes against humanity, international law crimes, murder, and genocide. The governing rule in this part, we have Section 7 of the Criminal Procedure Code that outlines sentencing jurisdiction of subordinate courts. Judicial interpretation, where the subordinate court acts outside jurisdiction, proceedings will be annulity and are correctable by supervisory or revision powers. What criminal matters fall within the jurisdiction of the High Court? The High Court has original jurisdiction in serious offences reserved to it by law. And in a classical example, you have murder. And appellate or supervisory or revisionary jurisdiction over subordinate courts' criminal proceedings. The governing rule is that the High Court's revisionary powers over subordinate courts is provided under Section 364 of the Criminal Procedure Code. High Court revision is not a substitute for appeal and is confined to subordinate court records. When may a criminal appeal lie directly to the Supreme Court? The answer is only in the narrow constitutional gateways, where we have interpretation and application of the Constitution, or certification that the matter is of general public importance, usually originating from the Court of Appeal. Certification threshold is strict. Issues must transcend the individual case and be of general public importance. What is the difference between appellate jurisdiction and revisionary jurisdiction? Appeal rehears and corrects errors on law or fact within the appellate framework, while revision is a supervisory correction of illegality, irregularity, impropriety in subordinate court proceedings, not on merits or rehearing, and often it is discretionary. If you want to check the governing rules, we have Section 364 of the Criminal Procedure Code that provides for the High Court's revisionary powers and limits. And Section 364(4) says that the High Court cannot convert an acquittal to conviction if you want to go the revisionary way, and that no revision at insistence of a party who could have appealed. Revision is not to be used as a substitute of an appeal, because the same is a discretionary power. Judicial interpretation, we have the case of Caroline Toom versus Republic, where the revision is not a substitute for appeal and cannot be used where appeal lay but was not pursued. And the High Court cannot revise an acquittal into a conviction. Those are the key takeaways. Explaining the jurisdiction of the Court of Appeal in criminal matters. The Court of Appeal is primarily the second appellate court in criminal matters, typically from High Court decisions, and it determines appeals mainly on matters of law in the second appeal structure. If you read the case of Samuel Kamau versus Republic 2013, the Court of Appeal is also the primary form for deciding whether a matter meets the Supreme Court certification threshold. What is the role of the ICC, International Criminal Court? The ICC prosecutes individuals for the most serious international crimes, where we have genocide, crimes against humanity, war crimes, aggression, where national systems are unwilling or unable genuinely to prosecute. It is not a general criminal appeal court for Kenyan matters. If you have raised your hand, you can just unmute and speak, because I'm using a very impactful method of analyzing. So the role of ICC is to try the most serious international crimes, and we have a Kenyan law anchor on domestication of the same. Section 3 of the International Crimes Act says that Kenya's cooperation and domestication framework will include the ICC, International Crimes Act, pursuant to Section 3. Differentiate between territorial jurisdiction and subject matter jurisdiction. Territorial jurisdiction is the court's power based on place of the offense. This is where it occurred, was completed, and where consequences happened. While on the other hand, subject matter jurisdiction is power based on the type of offense and the court legally authorized to try it. That is when it comes to criminal angle of differentiating between the two. Which court tries murder cases and why? The High Court tries murder cases under the prevailing statutory allocation. Historically and procedurally, murder has been treated as reserved to the High Court as the court of original jurisdiction. Whenever you'll be asked this question, the panel will be expecting you to have read the case of Charles Henry Nyaoke versus Cabinet Secretary, Ministry of Interior and Coordination and 4 others 2020. It was a Kisumu decision involving 3-judge bench. So it is a test to test you on current affairs, where the High Court confirmed as the proper forum under current framework, and challenges to commencing murder trials in the High Court have been rejected. And the same principles was held in the Republic versus Geoffrey Okuto Otieno and Aisha Jumwa Katana 2022, where the ratio decidendi was that the court found that the issues raised by the applicant regarding the constitutionality of commencing murder trials in the High Court, the alleged denial of an additional appellate tier, and the jurisdiction of magistrate court to try murder cases had already been conclusively determined by a competent court in Charles Henry Nyaoke versus Cabinet Secretary, Ministry of Interior and Coordination, and 4 others. The three-judge bench in that case held that while the current statutory framework for murder trials in the High Court is a historical accident lacking specific legal or policy justification, it is not an unlawful under the Constitution. The differentiation in appellate rights does not amount to discrimination, and the High Court retains original jurisdiction over murder cases. The state was directed to take steps to align the relevant statutory provisions with constitutional guarantees, but the timelines for compliance had not lapsed. Consequently, the applicant's request to satisfy the matter as raising a substantial question of law and to transfer the trial to the magistrate court was disallowed, as the issues had already been resolved and could not be litigated. So that is the rationale that the panel will be expecting to hear from you, whether the differentiation in appellant rights amounts to discrimination. And the High Court has categorically stated that that will not amount to discrimination. And then, how is jurisdiction determined where an offense is committed partially in Kenya and partially outside Kenya? This is where you apply the statutory rules on place of trial and territorial reach. Where any material or element occurred in Kenya, where you check, is there any act, omission, or consequences? Kenyan courts can assume jurisdiction, subject to the specific offense, creating statute and any extraterritorial clauses. Because you have some known as extradition proceedings that we will analyze later. So that is the test that you will apply in that situation. Then, a charge has been filed before a court lacking jurisdiction. What options are available? As the answer is, let me check the recording, okay. You raise a preliminary objection immediately. The court must down its tools. The usual outcomes are striking out or retaining the charge or moving the file to a competent court where the law permits. Remember, we saw situations where a court can transfer a file directly from the subordinate court to the High Court, and from the High Court to another High Court person to the judiciary bench book. If you're attempting to correct a subordinate court error through High Court supervision, revision is governed and limited by Section 364 of the Criminal Procedure Code. And he said that revision cannot be used as an appellate substitute and cannot cure everything. It is confined and controlled by Section 364 of the CPC, including the bar where appeal will lie. Section 364 of the CPC gives the High Court broad but tightly limited powers to correct subordinate court criminal proceedings on revision. When revision power arises, this applies to subordinate court proceedings whose record the High Court has called for, being reported to it for orders or which otherwise come to its knowledge. Remember, when I was doing this analysis, I tried as much as possible to expand on the governing provisions that give rise to a certain element that answers this question. So like for this situation, I delved deeper. If you see a highlighted mark in red, it means that I went beyond what the question expects. Because in this situation, we are raising a PO to challenge a charge that has been filed before a court lacking jurisdiction. We raise a PO for the court to down its tools. But then, I've delved deeper to what amounts to revision powers. Yes, Victor.
Thank you, Victor.
Okay.
I can see you have some good presentations, and allow me to add some few things on what you have just presented in the powers of High Court in revisions. As per the sections you've just projected, you find that in Kenya, the powers of the High Court in revisions are principally under the Criminal Procedure Code. And as you have said, they're found from Section 362 to 367, around there. So you see that the Kenyan High Court exercises this revisionary jurisdiction to satisfy itself as to the correctness, legality, and propriety of any findings, sentence, or order. And in such a case, you see that, or you may find that the High Court may call for and examine the record of any criminal proceedings before any subordinate courts. I'm sure you say that. You also say that High Court may correct any incorrect or any improper finding or any sentence or any order. So that process of correcting give rise to revisions. The other power of High Court in revision is that it may alter. Alter means changing or reverse any order or sentence which it might have found to be unconstitutional, which have found to be improper, or which it found to be unlawful. So you never say that. So it cannot correct anything, but it corrects those orders which are lawful, which are improper, or those orders which are unconstitutional. The other thing which you said, and I want to add on that, is that it may reduce or enhance a sentence. So, provided that these sentences affect the person affect the person, is given an opportunity to be heard before that sentence is imposed. So you ought to have said that. And the other thing is that the High Court may decline or interfere. I've said that the High Court may decline to interfere with no illegality or irregularity. I hope that you say that. So looking at section 354, 357, and 358 of the CPC, subject to the limitations which are applicable to revisions, the High Court may exercise any power or may exercise any appellate power that may be available to those sections. So the question which we may ask ourselves in that part may be, what are the limitations of this court jurisdiction on revisionary? What are the limitations of the revisionary jurisdiction of the High Court? Now, in trying to answer that question, we may say that High Court does not ordinarily reevaluate the evidence merely or only because it may have reached a different conclusions. So you take note of that. That's generally the function of the Court of Appeal. So that gives us the first limitation. Limitation in this case means that the High Court will not go beyond that. So it cannot reevaluate any evidence only because it has reached a different conclusion. So the court which can do that is the Court of Appeal. Number two, the High Court cannot convert an acquittal into a conviction through revision. Once the High Court is through the revision, you need to come back and convict that person who had been acquitted. You remember last time we were looking at the type of plea. Number three, the High Court must give an accused person an opportunity to be heard before making an order that is prejudicial, such as enhancing a sentence. That gives us another limitation. Also, the High Court will generally entertain revisions where appeal has been filed and is pending. It cannot. It will not entertain any revision so long as there's an appeal which is pending to be heard after it has been filed. The High Court will not come in and entertain any form of revision. So that those four areas which I've just said among the others, those are the four main. So those one give us the limitation of the revisionary powers of the High Court in revision. Now, what are the purpose of these revisions? The main purpose of revision, as you had said earlier, is to ensure that any court which is below the High Court, in short, those courts which are referred to as subordinate courts, act within the law. They ensure that they observe the proper procedure in the trial process, and they ensure that these courts issue a lawful and proper orders. So in ensuring all these three things which I've just said, that will enhance justice, and it is going to ensure that there is no miscarriage of justice without requiring a full appeal. So those are my submission on that.
Thank you so much, Victor, for that insightful additional points. And I can also read mine briefly because it is adding up on what you have discussed. And I was saying that the revision power is conferred to the High Court by Section 364 of the Criminal Procedure Code. And you have said directly what the High Court may do on revision. If there is a conviction, it cannot turn a conviction, an acquittal, to a conviction, and may exercise appellate type powers. It may enhance the sentence. If there is any other order, not an acquittal, it can enforce the same. It may alter or reverse that order. And we can say that there is what we call special bail stay power in specified serious offenses that has been listed in listed offenses, e.g. murder, robbery with violence, terrorism, narcotics, organized crimes under the Procamla Act, sexual offenses, and trafficking. This is where a subordinate court has granted bail and the DPP indicates intention to seek review. The High Court may stay the bail order for up to 14 days pending filing of the review application. This is important because it is not in every situation that you will be granted the special bail stay power pending review. So this is one of the areas that you must take note of, and it is provided under Section 364 1C of the CPC. Then Victor has told us about fair hearing safeguards under 364.2, that no procedural revision order against an accused unless the accused has had an opportunity to be heard. And there is an exception in that this hearing requirement does not apply where the subordinate court failed to pass a mandatory sentence required by the offense creating that law. Then Victor has also told us about ceiling on enhanced punishments. If the sentence being revised was passed by a subordinate court, the High Court cannot impose a greater punishment than the subordinate court could have legally imposed. And then we have absolute bar regarding acquittals. The High Court cannot convert an acquittal into a conviction on revisions. And then you have revision barred where appeal lay but wasn't filed. If an appeal lay and none was filed, revision will not be entertained at the insistence of the party who could have appealed. Those are the key takeaways when it comes to revisions. Then we move straight to topic number 3 on arrests. What is an arrest? An arrest is the lawful restraint of a person's liberty by lawful authority for purposes of bringing them before a court or preventing further offending. When may police arrest without a warrant? For this, I saw it fit to directly incorporate section 29 of the CPC on arrests by police officers without a warrant. A police officer may, without an order from a magistrate and without a warrant, arrest any person whom he suspects upon reasonable grounds of having committed a cognizable offense. B. Any person who commits a breach of the peace in his presence. And C. Any person who obstructs a police officer while in the execution of his duty or who has escaped or attempts to escape from lawful custody. And D. Any person in whose possession anything is found which may reasonably be suspected to be stolen property or who may reasonably be suspected of having committed an offense with reference to that thing. E. Any person whom he suspects upon reasonable grounds of being a deserter from the armed forces. And F. Any person whom he finds in a highway, yard, or other place during the night and whom he suspects upon reasonable grounds of having committed or being about to commit a felony. And G. Any person whom he finds in a street or public place during hours of darkness and whom he suspects upon reasonable grounds of having been there for an illegal or disorderly purpose or who is unable to give a satisfactory account of himself. And H. Any person whom he suspects upon reasonable grounds of having been concerned in an act committed at a place out of Kenya which, if committed in Kenya, will have been punishable as an offense and for which he is liable to be extradited under the Extradition, Contagious and Foreign Countries Act and or the Extradition Commonwealth Countries Act. Any person having in his possession without lawful excuse the burden of proving which excuse shall lie on that person, any implement of housebreaking, any released convict committing a breach of any provision described by section 344, any person for whom he has reasonable cause to believe a warrant of arrest has been issued. So those are the key takeaways on various instances where a police may arrest one without a warrant. Yes, Victor.
I also want to remind you that that it's not only police officers who can arrest. Also, remember that private person can effect an arrest, and this private person effecting the arrest where a person commits a felony in front of them or before them. This felony must be a cognizable offense. So that person or the person is reasonably believed to have committed this offense or is believed to have committed this offense will have to be arrested by the private person. The other party who can arrest apart from the private person are magistrates. When the person commit an offense within the jurisdictions of the magistrates. We also have the chief. They're also empowered to effect an arrest. Now, let me go back to the arrest by private persons. Once a private person has effected an arrest, they must use a reasonable force, not excessive force. And they have to take the accused person or the arrested person to the nearest police station and hand over to the officer commanding the station for rearrest. So that some of the things which before the police officer rearrest have to put into consideration. One, he or she have to ensure that the person who has been brought to them has not been armed or acted when that kind of arrest was being effected. So if the person has been armed or acted, they have to be treated first before they are being arrested. Now, the other thing, during this process of arrest, the Article 249 of the Constitution of Kenya have to be considered. This Article 249 provides that arrested person has a right to be informed in a language which he understands and the reason for the arrest. He has to be informed that he has a right to remain silent and the consequence of remaining silent. He also has a right to communicate with any person, including his advocate. He has a right to be brought before court as soon as before the expiry of 24 hours. And he also has a right to be released on reasonable bail and bond terms. So, in effecting this arrest, there are some of the judicial principles which Kenyan courts have consistently held, that an arrest without a warrant must be based on reasonable and probable grounds. And they must be based on the powers of the police officer to arrest. Those are the judicial principles on arrest. Also, when police officers are arresting the accused persons without warrant of arrest as provided for under Section 29 of the CPC, the some of the factors which limits or which are going to hinder this their duty in arresting without warrant. Allow me to mention some of the few of these factors. One is that police officers are normally faced with a lack of reasonable suspicion. You find that a police officer must have a reasonable and objective ground, which give us or which give them to believe that that person has committed or is about to commit a cognizable offense. But that is normally hindered by suspicion, normally hindered by rumors or allegations. All these are insufficient. So that make that person is going to be arrested without warrant to lack a reasonable suspicion for them to be arrested. So the other one is where the law require warrant. So if an offense is not the one for which an arrest without a warrant is cognizable or is authorized by law, the police officer must first obtain a warrant. And we find that the investigative process is continuous. It does not end. Even during the trial, the investigations continue. That's why we or the police officer normally do or are normally required to do the investigations. Once the Director of Public Prosecutions has approved the charges, then arrest must be effected. Or after the approval of the charges, they must obtain the warrant of arrest from the court to cure this problem which I've just said. Number 3 is that the availability of less restrictive measures, where the attendance before investigators or court can reasonably be secured through a summon or notice to appear. Arrest should not be used unnecessarily. So arrest should not be used as a punitive or oppressive means. You find that if an accused person has absconded the court 2 or 3 times without a reasonable cause, the warrant of arrest is issued. So that one again should be relooked at. Violations of the constitutional rights under Article 49 of the Constitution, an arrest is unlawful if the suspect is not informed promptly of the reason of the arrest or is denied access to communicate with others, including the counsel or his advocates. That's another limiting factor. Absence of necessity, whereby the arrest should only be used where it is necessary, for example, to prevent further offenses, to prevent interference of investigations, or to prevent interference of the witnesses, or to prevent escape, and to ensure the attendance of the court. So if this objective can be achieved without arrest, detention may be or will end up being unjustified. So another one is bad faith or in improper purpose, where an arrest is made to intimidate or harass or settle the civil disputes, or to recover debts, or exert pressure on a person that seem to be unlawful. So among others, you find that the protection of fundamental rights like Article 28, 29, 47, and 49 of the Constitution, which protect the dignity, freedom for fair administrative actions, and right to of arrested person. So any arrest that is unjustified infringes these rights and may be declared to be unconstitutional. So for that reason, we find that if an arrest without a warrant is made contrary to these limitations, that will mean that the arrest and detention, which has already been effected contrary to these limitations, will be unlawful. This kind of arrest or the arrested person may be released unconditionally if that happens. And the evidence obtained through unlawful conduct may be challenged in court, depending on the circumstances which led that person to be arrested. And finally, the state or prosecution or the responsible officer may be liable for the damages of false imprisonment or violation of the constitutional rights. So I beg to submit.
Thank you so much, Victor, for that very insightful discussion there. I have nothing to add because it is a very substantive one, and thank you so much for that input. Then the next question will be explain the procedure for executing an arrest warrant. This was short and brief to the point. And you start with the officer executes the warrant by identifying the suspect and informs them of the warrant or offense. Arrest and take the suspect without unnecessary delay before the court that issued it, unless there is security and bail terms being endorsed. And if executed outside the issuing court's local jurisdiction, you should take the arrested person before the nearest competent magistrate unless exceptions will apply. There are some enabling rules to this part where you have to execute an arrest warrant. If you read section 108 of the Criminal Procedure Code, it tells us on prompt production before a court of competent jurisdiction, and we have a section 112 of the CPC on execution outside jurisdiction where you are routing via a local magistrate. Then section 103 of the CPC, warrant may be endorsed for release on bond or securities in non-excluded offenses. So I like to indulge you to analyze those provisions deeply when you are answering that question. And this, I believe, will also form an application questions arising from the same. You can be told to do an application before court for an arrest warrant to be issued to an officer. Okay, so those are the drafting elements coming out from these parts. What constitutional rights accrue immediately upon arrest?
So you
Yes, yes.
be expecting a warrant of arrest. Is that the case?
Yes, yes, Victor.
When effecting a warrant of arrest, it involves around 8 procedures. And these procedures are normally governed by the Criminal Procedure Code and the National Police Service Act. And some of the key procedures are: one, issuance of the warrant. You find that a warrant of arrest is normally issued by the competent court. So you must mention the competent court. And it has to be signed by a magistrate or a judge. A magistrate is the appointed court, or a judge for the high courts. And it must bear the court seal and specify the person to be arrested. So we are first issued with the warrant of arrest. So remember the person issuing it, and remember the person to whom that's going to be effected to. So we are being guided by section 95 to 103 of the Criminal Procedure Code and article 49 of the Constitution. Number 2 is on after being issued with the warrant, what you have to do is to execute the warrant, execution of warrant. So the warrant is normally directed to police officer, but the court may also direct that warrant to another person who is authorized by law to effect the warrant. That can be the chief or any other person in authority. So the executing officer must ensure that the warrant is valid before executing it. So that means they'll have to go back to court and find out if that warrant is genuine. Number 3, identification. That means the police officer should identify themselves as police officer where practicable. And if requested, the police officer must produce the warrant or notify the person of the existence of an offense for the purpose of arrest. Number 4, the fourth procedure is now arrest, whereby the police officer shall effect the arrest on the person who has been named in that document, which is known as the warrant of arrest. And in such a case, the reasonable force may be used only where necessary if that person tried to resist or if that person tried to effect the arrest. Remember, excessive force is prohibited, not allowed. Then number 5, after arresting, search is done to that person. And this person who is carrying the search must identify the weapons being found or any other article which are relevant to the offense in accordance with the law. So any property which is found during the process of search must be documented. Procedure number 6, after search, we now inform the arrested person of the reason why he has been arrested, the right to remain silent, right to communicate with advocates, and any other rights. Procedure number 7, within 24 hours or before the expiry of 24 hours, keeping other factors constant, being a weekend or or a public holiday, the arrested person must be brought before the competent court, which issued that warrant. Then, procedure number 8, you return the warrant after execution. So these are the main procedures which we have to follow. Remember that as in a case scenario may come out of that, which requires to give that. You remember Article 49 of the Constitution. Remember Section 95 to 103 of the CPC. And the most important legal principles in this procedure is that a warrant of arrest may be executed anywhere within Kenya. Also remember that the officer must respect the constitutional rights of the person to be arrested, and failure to comply with the two legal principles I've stated will lead to the release of that person who has been arrested.
Thank you so much, Victor, for that additional and very procedural procedure and steps to answer that question. And the next question, we were discussing on what constitutional rights accrue immediately upon arrest. You have the right to be informed promptly of reasons for arrest and the charge in a language that the arrested person will understand, the right to remain silent and not incriminate oneself, and the right to communicate with an advocate and other persons, to be produced in court within constitutionally required time, and bail where applicable. So those are the three main rights that will accrue immediately upon arrest. What force may be lawfully be used during an arrest? Only reasonable and proportionate force necessary to effect lawful arrest, because excessive force is unlawful and triggers criminal or civil and constitutional remedies, as Victor has directly informed us. When may a private citizen effect an arrest? This is typically where a person is caught in the act or immediately after committing an offense, or to prevent an escape. Then if you check section 34 on arrest by private person, is where a private person may arrest any person who is in his view commits a cognizable offense, or whom he reasonably suspects of having committed a felony. And persons found committing an offense involving injury to property may be arrested without a warrant by the owner of the property or his servants or persons authorized by him. Those are the various ways where a private individual can effect an arrest. And Victor has gone a step further to tell us what happens after you have arrested this person if you are a private citizen. Then the next question is to differentiate between arrest and detention. Arrest is the act of taking a person into custody, while detention is the continued custody or confinement after arrest, pending charge, inquiries, or trial, and must be legally justified and time-bound. What remedies are available where an arrest is unlawful? There is a constitutional petition for violation of rights where you can seek declaration, compensation, conservatory orders. There is a civil suit where we have false imprisonment, assault or battery, malicious prosecution where applicable. We have exclusion of unlawfully obtained evidence where it undermines fair trial. That is also a remedy where an arrest is unlawful. Then we have disciplinary or criminal proceedings against offending officers where you can use IPOA or National Police Service internal mechanisms. Then draft the essential contents of an application challenging unlawful arrest. And in this situation, I decided to go with a petition and give the various elements of this petition, where we have the title, parties, jurisdiction, facts of arrest, specific rights being violated, and the articles to be pleaded with precision. And by this, I'm doing a petition for habeas corpus. And then amongst the relief that I can claim is declaration of violation, compensation, orders restraining further harassment, production before court, or release where lawful. Can an accused resist an unlawful arrest? And the answer is generally do not resist physically. challenge legality in court. Resistance risk. Okay.
You can before
Victor. Okay.
you draft the essential contents of an application challenging unlawful arrest. I think what you have just provided there are not sufficient to guide us to answer the question. And as per what I have, I also have around 9 or 10 contents. Will you allow me to?
Yes.
So the title of the proceedings, that's the first one. In the title of the proceedings, we have the name of the court. We have the case number. Then we have the name of the parties. The parties in our applications. That's the applicant and petitioner or respondent. Now, before we write the parties, we have the legal provisions which we are going to invoke, and the application must cite one, the Constitution of Kenya 2010 on enforcement of bills of rights. So we cite in the matter of, then we have that provision. Then Constitution of Kenya 2010 on the authority of the High Court to grant relief. Just below that one, you write and then below and we have the matter of right. That one, then we have the Constitution of Kenya on the freedom and security of persons. You also provide the article. Below that one, we have the right of the person. You also have and then in the matter of, then we provide the right of the person, right to fair and hearing. Then we also have the Criminal Procedure and the National Police Service Act. Then just below that one, we write between the name of the applicant and then the name of the respondent. Now, the first paragraph are the particulars of the arrest, the date, time, and the place of the arrest. We identify the arresting officers, if we know. We also provide the circumstances which led to the arrest. We also provide where the arresting officer identified themselves. And we also provide whether the applicant was informed of the reason for the arrest. Number 4 are the grounds of challenge. Grounds of the challenge. The applicant should state why the arrest was considered to be unlawful. For example, you may find that the applicant saying the arrest was made without lawful authority. There was no reasonable suspicion that an offense had been committed. Failure to inform the applicant on the reason of the arrest. So we provide. Then after that we move in and draw or draft our supporting affidavit, which should set out the facts in chronological order. We annex the relevant documents such as charge sheets, such as OB extract, P3, witness statement, or any correspondence with the relevant authorities. Then we have the constitutional violations alleged. We provide the relief sort. And finally, our prayers for its urgent. Are you praying for conservatory orders, temporary injunctions, orders which restrain further arrest pending terminations of the application before the court? So I think those are the main content. Immediately after that, remember that I've said supporting affidavit must come at the end. And this application is mainly in petition form. You can proceed, Victor, from your end.
Thank you so much, Victor. And I believe you're doing a petition for habeas corpus, right?
Yes, yes.
So, and it is supported. So, from the judiciary bench book, we did a constitutional petition. We annexed a notice of motion under certificate of urgency for interim production orders. Then we did a supporting affidavit. That is the procedure. That is what we saw the judiciary bench book providing for when you are doing. Thank you for that confirmation. Then, can an accused person resist an unlawful arrest? And we say generally no. You don't resist physically, you challenge the legality in court. Then we go to topic number 4 on identification parades. What is an ID parade? An identification parade is a police control procedure where a witness is asked to identify a suspect from a group of similar looking persons to test the reliability of the witness's identification. When is an ID parade necessary? It is necessary where the suspect is not previously known to the identifying.
I think you are muted from your end. Maybe you can unmute and continue.
Oh, apologies. I was muted. So I had started with topic number 4 on ID parades, and as I have asked a question on what is an ID parade, and this is generally a police control procedure where a witness is asked to identify a suspect from a group of similar looking persons to test the reliability of the witness's identification, and it is provided in the National Police Standing Orders. When is an identification parade necessary? It is necessary where 1. The suspect is not previously known to the identifying witness, or conditions of identification were difficult. We have to look at the lighting, the duration, and the stress, and the prosecution needs to test reliability. And 3. The prosecution intends to rely substantially on visual identification or recognition. So maybe this is a part where, Victor, you can tell us the difference between recognition and identification parade aspect, and which one has more weight than the other. We have doc identification, which is a weaker mechanism. We have, yes?
You ask a question. Maybe before, I think on whatever I'm going to say, will answer you. So I'll request for 2-3 minutes. One, we have said that we have identification parade and dog parade. Remember that dog parade is normally carried out during the trial process in court. But identification parade is usually conducted before a person is presented to court, and it's conducted in accordance with the serving standing orders of National Police Service, and the procedure is usually designed to ensure that there is fairness to both the suspect and the witness, and mainly to preserve the integrity of the process of investigations. So usually the main steps which identification parade follows are that one, the suspects is usually informed of their right, or the suspect whom was arrested have to be informed that identification parade is going to be conducted, and the reason why it's have to be conducted.
Victor, you are breaking.
Or any other independent person to come and witness that process. The accused person also have to be informed of the right to refuse the process to be conducted. So the suspects have to be placed among at least 8 persons. These 8 persons must be of similar age, height, and general appearance, or with complexions and the social class where practicable. So if there are more than one suspect, each suspect should be placed in a separate parade. We should not place all the suspect in one parade consisting of at least 8 persons. So the suspect is allowed to choose their position in the line. After each witness has viewed the parade, the suspect is expected, or the suspect may change the position if he or she wish. Now, each witness is taken through the parade individually, not with the other suspects, not with the other witnesses. So the witness must communicate. Sorry, I've said that the witness must not communicate with one another after or before the process of parade identification. So the witness is brought to the parade without being told where that suspect is standing. It will be his duty to identify where the suspect is. So witness is asked to identify the person whom they saw during the commission of the offense. So if the witness identifies the person, they should indicate that person by touching on their bodies. So the officer conducting the parade must record the name of all the persons who are in the parade, the position of the suspect, whether the suspect in the position, the witness response after identifying, any objections or comment made by the suspect, and whether the suspect was satisfied with how the parade was conducted. So the suspect in this case is invited to sign that parade identification form. Remember, again, is not forced. He can choose not to sign. So in such a case, the officer conducting the parade should not be that officer who investigated the case. He may be present, but should not oversee the process. The second thing you must remember is that the suspect must not be pointed out or separated from the others in the parade. So the witness must also not see the suspect before the parade. It should be the first time, apart from seeing the suspect in the crime scene. And the parade must be conducted fairly without any suggestion or any. Remember, if the identification parade is going to be conducted, the parties who are going to be in ID parade must not be police officers, not unless the police officers themselves are the one who are being accused. So I take you back to why the ID parade is necessary. Remember that an ID parade is an investigative process which is conducted to test whether the witness can correctly identify the suspect whom they claim to have seen at the crime scene. So remember also that I've told you that this process is mainly governed by the service standing orders for the police service, and this ID parade is conducted in the following circumstances where there is only eyewitness evidence linking the suspect to the offense. Where there's only eyewitness linking the suspect to the offense. That is one. Remember, there's something which you have just raised on mistaken identification. That a person was seen in the crime scene, and we place that crime scene, we place another person with that crime scene wrongfully. That will lead to wrong conviction, and the courts usually expect some strict compliance on the identification. So to avoid that, ID parade is usually conducted to remedy the problem which may come out in the doc identification. So where the suspect is not previously known to the witness, ID parade will be conducted. But if the suspect was previously known by the witness, what will remain only is a doc parade, doc identification, where the witness will identify the suspect while he or she is in dock. So the witness later he have seen the offender but not know that be required to identify them before linking the suspect to the evidence. The other reason why it says depends where the identity of the offender is in dispute. If the suspect denies being the person who committed the offense, an ID parade will provide an independent test. And the other one, where the offense occurred under different difficult conditions, such as at night, such as during the between the witness and the accused, ID parade will be necessary. So, identification parade, remember, can also be unnecessary in the following situation. Just that the witness knew the suspect well before. The suspect may be your neighbor, so you know your neighbor maybe for the years you have lived in your life. So there will be no need for the investigating officers and as a witness to conduct the ID parade. But if you have encounter with the accused for a short period, then for you to be sure, ID parade will have to be conducted so that you can link that suspect to the crime scene and how long have you seen the suspect. The other reason or other way where ID parade may not be necessary is where the other conclusive evidence which established the identity, making that ID parade to be unnecessary. Like we have the CCTV footages which identify an accused to the crime, like a crime scene of arson or robbery. Then we can retrieve the CCTV. ID parade will be unnecessary. Also, if the suspect was arrested at the scene or immediately after the offense, and the circumstances which leave no doubt as to the identity, ID parade will not be necessarily in such a case. So the suspect voluntarily admits and surrenders himself. For example, in case of has committed a crime of murder and surrenders himself to police authorities, that will not warrant the ID parade. Now, you may also ask yourself, then, what will be the objectives of conducting the ID parade? Allow me to give you 2 or 3 objectives. One, ID parade is usually important because it reduces the risk of wrongful convictions based on unreliable eyewitness testimony. The second one, it protects the person from mistaken identity. The other one, it provides the accuracy and reliability of witness recollection of what he or she witnessed when that incident happened. The other one is that it ensures fairness to the suspect during investigation process. So those are all about the ID parade. Remember the steps. The steps I inform you that the ID parade involves several procedures. From when that witness record the statement to when the ID parade form. And I classified them into 6, whereby we have the suspect is informed of the rights. The second one, selection of the parade numbers. The other one, choice of positions. And we have witness kept in different roles, see what happens. And speaking of the ID parade, then calling proceedings and to be that unless there's any other thing concerning the ID, I think you can continue. Remember that the ID parade after arrest, it cannot happen before arrest. Then the dog parade usually happens during trial process in court. And the ID parade form usually form parts of sub 5D. It's a witness statement on its own. And it's different from the doc identification. Doc identification, person whom you have encountered with him or her severally on different occasions, so you know that person. And the prosecutor is going to ask you as a witness, do you see the accused person by this court? And then you as a witness you say yes, sitting there or standing there. That is during the examination in chief. So you can continue, Victor.
Thank you, Victor, for that information, but I'll caution you on the grounds for using dog parade because it is the weakest form of evidence because it is automatically that the accused person will say the witness will point at the person standing on the dock. So the key factor to distinguish between the two is that recognition, we have ID parade, and then we have dock identification. And for dock to be applicable, you should now tie it together with the ID parade for it to have a corroborative effect. Thank you so much, Victor, for that insightful discussion. And who should conduct an identification parade? This is a police officer independent of the investigations into the offense, because he should not be the arresting officer or the IO. This is to avoid suggestions or contamination. What rights does a suspect enjoy during an ID parade? The rights that a suspect enjoys is to be informed of the procedure and allegation, to have parade members of similar appearance, to choose position and change position between witnesses, to have any objections recorded on the form, not to be unfairly exposed to witnesses beforehand, and even the right to enter into this identification parade voluntarily, because it should not be forced towards him. What defects may render an ID parade worthless? This is where you will commit various mistakes, where the witness saw suspect before the parade. This amounts to contamination. No prior description was recorded. Witnesses only identifies at parade or at the dock. So prior description is required. Parade members are dissimilar or suspect stands out from the rest. And same parade members reused repeatedly for multiple witnesses and or cases. Police prompting or suggestion. Poor documentation, where we have missing parade forms and signed forms, will be a flawed parade. Explain the evidential value of dock identification. Dock identification is generally worthless and safe unless preceded by a properly conducted identification parade or supported by strong independent evidence. How is Form P156 completed? Form P156 is the identification parade form. It is completed by the parade officer to capture the following. It captures the date, the case, the OB reference, and the suspect details. It captures the parade composition on number and particulars of members. It captures the suspect's right being explained to him, suspect's position, choices, witness entry and exit times. We have identification result and words that were actually used by the suspect after identification. Then we have objections and complaints by suspect and how the same were addressed, and signatures of the parading officer, suspect, and witnesses as required in that form. What objections may defense counsel raise regarding identification evidence? The defense counsel may raise no prior description given to police. Okay.
Just a few things on the common defect of, a few things on what renders the ID parade to be defective. Let me highlight them. Is that one of them? If a witness saw the suspect before the ID parade, then that ID parade will be defective. And what you must know in this case is that this witness may see the suspect maybe in TV or any other media, the social media, or in police station, and being shown that is the suspect who committed that crime in wherever they were, then that will allow the ID parade to be defective because the witness have seen the suspect and objective in this case will have not been met. The other one is that identification of the multiple suspects being placed in the same ID parade, that will be. And what I said earlier is that each suspect must come in his or her parade. So if you have the 10 suspects, we must have 10 ID parade being conducted. Then the other one is that the suspect is required to wear distinctive clothing to or display a unique features that matches the witness description, while the other parade members do not. So remember that when you are conducting the ID parade, we said thing must be the same. But one of the parties with a suspect where something is going to be different from the other members, then this will be render our parade to be defective. The proceedings are not properly recorded. You fail to record any objection like you said, that parade will be defective. A witness is told the suspect in certain place maybe is the fifth person from from your right. Then it will be defective. The investigating officer conducting the parade himself, that will again to be effective. Just court. The other one is communication with one another. The witnesses communicating with one another that are seeming is wearing a cap and he has no shoe. So that communication between the witnesses render the parade to be defective. And if the parade consists of less than 8 members, then that parade is going to be defective. So it must contain not fewer than 8 members, excluding the parade officer. Remember that the parade officer is not included in the ID parade unless otherwise justified. Now, you have also asked a question on filling ID parade forms. The information which are required when filling the ID parade forms. We have the case particulars, and the case particulars contains the police station, the OB number, the CR or police file number, then nature of the case, date and place where the parade was conducted. The second thing is the particulars of the suspect. Well, the name, age, gender, physical description, position occupied in the parade. Now, remember that we said the suspect can change position during the ID parade. So if we have, for example, 3 witnesses, then we are going to describe 3 places where the suspect went to when he was changing the positions. Number 3, you have the particulars of the parade members. The names and the number of persons on the parade. Remember that the parade must contain at least 8 persons placed beside the suspect. Confirmation that they were of similar age, similar height, complexions, and appearance. So you have to indicate them there. And you also have to write the rights which we have explained to the suspect. Then, witness details for each witness. Witness detail for each witness. That's the name, the time the witness viewed the parade, whether the witness identified the person, and if they identify the person, which position in that line, in that parade, was that person who was identified standing in. Then, changes of the position. You record whether the suspect decided to change the position from one point to another, or he just stayed at that one point where he was. Then the suspect come after each witness have identified that the suspect is the third person in the parade of 8 or 9 persons. What were his reactions? You record. if he accepted or made any kind of objections during the parade or after the parade, you record. Then record whether the suspect was satisfied with the process. Record his comments. Then certification now, this is where the suspect will come in and record his signature. His advocate, if is present, put his signature as an independent observer. And if the suspect refused to sign, you can place a note on the reasons which he gave that he was not going to sign the process. And I think those are 10 main parts which will be recorded in ID parade form. So all those parts are important. And remember that if the accused number of accused person are 20, you're going to fill 20 ID parade forms. If the witnesses who are identifying the accused are 50, you have to record them with them the details, including the names, time when that person is part of the parade, the witness statement on each identification of the witnesses, and if an ID parade was made, the person identified and the manner of identification. Was it by touching or talking to that person? Remember that during the process of conducting an ID parade, if a witness wish to talk to the accused person or the suspect, he can talk to that person. Yeah, I'm done. Maybe you can proceed from your end.
Thank you so much for the practical element of it. And maybe Victor, I can ask you and Albert, what is the projected time that you want us to end this session? Because I'm inclined towards your schedules. Any suggestion, or we just proceed?
You can proceed.
Okay.
It's 10, 10, 10, I don't know where you are.
Sorry? So Albert has said any time. Victor, you're asking?
The time in where I am now is 10
Okay.
p.m. 10:27 p.m. I don't know what's the time there.
It is 1:27 a.m.
Or maybe sooner to tell us.
But no worries, because I intended to do this unit in a quicker manner so that we do away with criminal litigation oral session, then we can embark on other units, because we are using a method of exhaustion. Then, can an accused refuse to participate in an ID parade? And the answer is yes. A suspect may refuse, but the refusal can have evidential consequences. The prosecution may rely on other evidence, and refusal may be argued in context, because the defense should insist that refusal and reasons is properly recorded. So it will turn out to be having evidential consequences if the suspect refuses to engage in an ID parade. Then topic number 5, we have preparation of files for trial. What documents constitute a police investigation file? And typically, Victor conducted a full session on police files. And briefly, this is an open-ended question. You just say what is in the police investigation file. We have OB extracts or occurrence reports and investigation diaries. We have witness statements and suspect statements. We have exhibit memo forms, seizure and recovery inventories, and chain of custody records. We have scene of crime documentation, photos and sketch plans. We have forensic reports. We have identification parade forms, if any, and arrest reports. Then what are the contents of a prosecution file? This is where we have the charge sheet and key witness list. We have witness statements and documentary exhibits. We have expert reports and exhibit schedules. Then we have disclosure index, we have correspondence or instructions, we have trial strategy notes, we have bail opposition material where applicable. And what documents should be contained in an advocate's criminal litigation file. We have client's instructions and attendance notes, proof of identity, contact list of kin. We have charge sheet, bail terms, court orders, proceedings, and typed notes. We have disclosure received, defense witness statements, exhibits, authorities list. We have applications, maybe application on bail, exclusion, recall witnesses, adjournment, revision, or appeals. Then you have the trial plan. You have the cross-examination matrix, inconsistencies log, and exhibit objections list. What is contained in a court file? We have the charge sheet or information if it's a high court. We have plea record or quorum. We have all filed applications and rulings in that matter. We have witness testimonies and record of proceedings, and we have exhibits list or court orders and judgment and sentence. Explain the importance of witness statements. This fixes witness accounts early, supports cross-examination and impeachments, it aids disclosure, compliance, and fair trial, and it helps identify contradiction, gaps, and necessary applications. When should witness statements be supplied to the defense? Before trial, in advance of hearing, so that the accused has reasonable access and time to prepare. The statutory anchor is Section 42A of the Criminal Procedure Code, on where the prosecution of disclosure obligation is directly required from them. What documents must be disclosed before trial? At minimum, you should disclose witness statements, expert reports, exhibit lists and copies, or access for inspection. Any documentary evidence the prosecution intends to rely on, and potentially exculpatory material subject to statutory exceptions. Section 42A of the Criminal Procedure Code provides that its exceptions, informant identity, witness intimidation risk, and national security, this is where disclosure may also be in camera. So Section 42A is important because it tries to tell us the various exceptions why you can be limited in accessing some documents. National security, informant identity, and witness intimidation risk that you can pose to them. Explain the constitutional basis for disclosure. Disclosure flows from the fair trial right, where the accused must be informed in advance of the evidence the prosecution intends to rely on and have reasonable access to it. How should exhibits be organized in the trial file? You create an exhibit register where you have description, source witness, date recovered, memo, form, reference number, and storage and location. You separate documentary, physical, and electronic documents. You maintain chain of custody documents behind each exhibit tab, because when the chain of custody is broken, that is a ground for challenging the documentary chain. Then pre-mark with intended producing witnesses and admissibility issues. So that is how practically you list down and organize your exhibits in a trial file. What ethical obligations arise when reviewing prosecution files? The ethical obligation number 1 is confidentiality and proper handling of disclosed material. No witness interference or intimidation. Candor to court, don't mislead on disclosure status, and advise court on realistic risk and plea options and consequences. Then topic number 6 on complaints and charges. What is a complaint? A complaint is the allegation made to a magistrate that an offense has been committed by a named or identifiable person, forming a lawful basis for instituting criminal proceedings. This is provided under Section 89 of the Criminal Procedure Code, that proceedings may be instituted by making a complaint or by bringing an arrested person before a magistrate. So it is a complaint, it is an allegation made to a magistrate that an offense has been committed by a named or identifiable person, forming a lawful basis for instituting criminal proceedings. Differentiate between a complaint and a charge sheet. A complaint is the initiating procedure of an allegation to court, either orally or written, and reduced to writing if oral. While on the other hand, a charge sheet is a formal charge. It is the formal written accusation setting out specific offenses and particulars. It is signed and presented by court or police as provided, upon which plea will be taken. Section 89(3) to 5 of the CPC provides that the complaint form and the magistrate duty to draw or sign a formal charge unless presented by police. What are the essential ingredients of a valid charge? A valid charge must contain the following. It must state the specific offense where you provide the law plus the section being violated. Number 2, provide particulars sufficient to give reasonable notice. Who, what, where, when, how, as required by the offense. Then you have B, 3, it must be clear, non-duplicitous, and properly framed because counts separated where multiple offenses will be observed. Those are the essential ingredients of a valid charge. And the rule to that is provided under section 134 of the Criminal Procedure Code. Explain duplicity in criminal charges. A charge is duplex or duplicitous where more than one offense is charged in the same count, creating uncertainty and prejudice because the accused cannot tell exactly what case to meet or defend. Each offense must be in a separate count, pursuant to section 135(2) of the Criminal Procedure Code. Receiving plus retaining in one count is fatal duplicity. Burglary or stealing combined or pleaded in the alternative is one count is duplex and unsafe. How should alternative charges be framed? Frame the main count first, then an alternative count for a related but mutually exclusive offense arising from the same facts, e.g. stealing or handling. The court should not convict on both main and alternative for the same act. We have a case scenario where convicting on both main and alternative form from the same fact is wrong. When may counts be joined? This is testing on the issue of joinder of counts pursuant to section 135(1) of the CPC. Counts may be joined in one charge sheet or information if offences are found on the same facts or form part of a series of offences of the same or similar character. Those are the two areas where the counts may be joined. Same facts or form part of a series of offences of the same or similar character. Courts can order separate trials if joinder will embarrass or prejudice the defense, pursuant to section 135(3) of the CPC. When may accused persons be jointly charged? This is now on joinder of persons, where persons are accused of 1. The same offense in the same transaction, or offenses arising out of the same transaction. Those are the two elements. So it is important for us to distinguish between the two clearly. Joinder of issues. If the offenses is founded on the same facts or form part of a series of offenses of the same or similar character. Series of offenses and founded on the same facts. While on the other hand, on joinder of parties of accused persons, the same offense in the same transaction or offenses arising out of the same transaction, pursuant to section 136, while the other one is pursuant to section 135(1) of the CPC. Explain conspiracy charges. Conspiracy is an agreement between two or more persons to commit an unlawful act or a lawful act by unlawful means. The offense is the agreement itself, even if the planned offense is not completed. This is subject to specific conspiracy provisions in the Penal Code and other statutes that try to create it. So the offense is the agreement itself, even if the planned offense is not completed. That is what amounts to a conspiracy charge. Explain attempt offenses. Attempt is where a person with intent to commit an offense does an act which is more than mere preparation and is a direct movement towards commission, but the offense is not completed. So for attempt, you have already done an act which is more than preparation and is a direct movement towards commission of that offense, but you have been caught when you have not yet completed the same. When may a charge sheet be amended? A charge sheet may be amended at any stage of trial where there is variance or defect and amendment is necessary, provided the accused is protected from prejudice. And where a charge sheet has been amended, it is important to call the accused person to take a fresh plea on the amendment, and that accused person can recall witnesses if demanded, and adjournment is misled in some situations where you adjourn after an amendment. Amendment in subordinate court trials is provided under Section 214 of the CPC, while amendment of information in High Court trial is provided under Section 275 of the CPC. What prejudice may arise from amendment of charges? One of the prejudice is that it can lead to surprise or new case theory, and as a result will lead to inadequate time to prepare. There can be loss of earlier defense strategy and inability to test evidence already led unless witnesses are recalled, and there is a risk of curing a defective case midstream unfairly. What are the safeguards? You take a fresh plea on it, then you give that person the right to recall witnesses. Then we have seen in the criminal bench book that it is not fatal if you don't call the accused person to take a fresh plea on it, provided it will not be prejudicial, provided the amendment will not be prejudicial to the rights of the defense person, of the accused person to prepare a defense. And one of the example was that in an attempted robbery, the charge sheet was amended to introduce another count on engaging in firearms, having unlicensed firearms in possession, and the court reasoned that that is reasonable and will not lead to prejudice of the accused person, because at the end of the day those are related and form part of the same transaction. So those are the elements that the court will consider, because in that case the accused person was not called to take a fresh plea on the amendment. What remedies are available where a charge is defective? This will depend on the defect and stage. If it is pre-plea, you go with objection. Courts can refuse to admit charge if it discloses no offense. During trial, you seek striking out. You seek severance or separate trial or amendment with safeguards, and on appeal, conviction may be quashed if defect cause prejudice or miscarriage of justice. If you read Section 89(5) of the CPC, magistrate must refuse to admit a complaint or charge that discloses no offense. And Section 135(3) of the CPC, joinder will lead to prejudice, then you should order separate trial order. You can order separate trial where joinder will lead to prejudice. Explain the procedure for quashing a defective charge. If in the High Court on information, move to quash where the information does not state and cannot be amended to state an offense of which the accused had notice before plea or in arrest of judgment. This is where I beg you to read Section 276 of the CPC, because for subordinate court charge sheets, you typically object and seek refusal and admission and amendment under Section 214 or strike out, then appeal or revision if wrongly handled. So there are two situations to handle the same, and for that one we'll call for a detailed explanation if you read the two provisions. Draft the structure of a proper charge sheet. So this is how it will appear in a summary manner. The minimum structure before you. We have the case title, Republic versus Accused, court, and the case number. Then you go to the counts numbered, count number 1, count number 2. Each count should have a statement of offense, a robbery with violence contrary to section this. Each count will also have particulars, and the particulars will have a date, time, place, complainant, property, act, weapon, violence, intent as applicable. Alternative counts clearly labeled as alternative charge under the main count if any, and then witness list and exhibit list where practice requires, but it is not always on the face of the charge sheet, and signature and date and name of the prosecutor or a drafting officer. We will have an active session where we are drafting a charge sheet, and that session I'll give Victor to draft a charge sheet on our feet so that we appreciate various elements and we test whether we have mastered the various rules on framing of charges and counts pursuant to section 134 of the CPC. We will test the application of section 134 of the CPC to the actual drafting of the same, because it is a technical scenario, and we have seen CLE asking students of late to draft various parts of the same. Identify common drafting mistakes in criminal charges. We have duplicity, where these are two offenses in one count. We have wrong section, where you charge two overlapping sections in one count improperly. We have missing essential particulars. You have not listed the date, place, complainant, property, act, and intent. We have inconsistent complainant between main and alternative counts. We have joining unrelated offenses or accused persons without same facts or transaction basis. Those are the common drafting mistakes that you will also do whenever you are told to draft a charge sheet. This is the reason why we must practice in real time. And then we can read a decision where amended charge sheet was struck out for duplicity and causing confusion as to the complainant and the offense being created. This was the case of Alticide, Brilliant versus Republic 2015, where the court found that the amended charge sheet was bad for duplicity because each count and its alternative charge named different complainants for the same transaction, making it impossible for the appellant to know which offense he was required to defend. The draftsmanship of the charge sheet amounted to joining two offenses under the same charge, which is prohibited. This confusion would prejudice the appellant's right to a fair trial and proper defense, and the court held that the offense of obtaining money by false pretenses cannot be an alternative to stealing by servant when the complainants are different. The ground that the charge sheet was not signed could not stand, as the document bore official stamps and signatures, and the magistrate had not signed due to the pending objection. The appeal was allowed, and the ruling of the trial magistrate was set aside, and the amended charge sheet was struck out. Topic number 7, plea and plea bargain. Explain the procedure for taking a plea. In the subordinate court, court states the substance of the charge to the accused and asks for plea. You can either say not guilty, guilty, or guilty subject to plea agreement. If guilty, not via plea agreement, record admission as nearly as possible in the accused's own words. Convict, then take facts. Court may permit or require complainant to outline facts before sentencing or order. If not guilty, proceed to hearing. If accused refuses to plead, enter a plea of not guilty. We have analyzed the judicial bench book, and it has categorically and in details explained what happens at every stage. You use the language that the accused person understands, but not the language that they will prefer. The other key takeaway is that after a guilty plea has been entered, the court will cause the prosecutor to read out the facts, and these facts are not tied to the charge sheet, so that this accused person will have the right to understand the facts fully, because the charge sheet is confined to particulars of the offense. Those are the nitty-gritties that you will appreciate when you read that book. Then we can see some situations where some instances where the court will enter a plea of not guilty. If the accused refuses to plead, enter a plea of not guilty. If the accused person challenges the facts, enter a plea of not guilty. If the accused person challenges the counts or the charges being read to him, you enter a plea of not guilty. Those are the nitty-gritties that you must understand. Differentiate between an equivocal plea and an unequivocal plea. An unequivocal plea, this is a clear, informed admission to all essential ingredients of the offense. No qualification or defense is raised, and facts support the charge. Equivocal plea is an ambiguity on understanding or language, unclear admission, and facts don't support charge, or accused qualifies and denies an ingredient even during mitigation. Where record doesn't show language understood and admission of ingredients, plea is not unequivocal. That is an interpretation that was held in FKC versus Republic 2022. When should a court reject a plea? A court should reject a guilty plea where it is not unequivocal, e.g., accused does not understand the charge and ingredients, or facts do not disclose the offense, or accused raises a qualification or defense. Court may decline to convict unless there appears sufficient cause to the contrary. What is plea bargaining? A plea bargain or a plea agreement is a negotiated agreement between the prosecution and the accused after charge but before judgment, where the accused pleads to a charge, often reduced on limited counts in exchange for specified prosecutorial concessions, and may include restitution or compensation. Remember, we said in the judicial bench book that there are some scopes and timings that will guide you whenever you are entering into a plea agreement. And the scope number 1 is where the accused person will want to have a reduced charges, a reduced number of various counts that they want the prosecution to drop on his behalf. And the prosecution should also involve the victim and should also take their views into consideration. But at the end of the day, it is the prosecution who has this discretion. It is the prosecutor who has this discretion to enter into this plea bargain agreement. Outline the procedure for plea bargain under Kenyan law. We have initiation by prosecutor or accused or his advocate. You notify court of intention to negotiate and court must not participate in it. Agreement concluded in the prescribed manner and form. In private prosecutions, DPP's written consent will be required. In open court, the court must satisfy itself that the accused acted voluntarily, was competent and understood the right, and he wavered on the right maybe to bail and bond, the right for forfeiture, restitution, compensation, and appeal limitation. Prosecutor provides factual basis and the court will record it. This is very important because remember, if the court declines to give you the order that they have taken your plea agreement into consideration, the chances of appeal is limited, and the only avenues where you can appeal that decision is where the order or the plea bargain agreement was entered through corruption, misrepresentation, or fraud. Court either accepts and convicts accordingly or rejects, and the reasons to be recorded, and the plea becomes null, and a plea of not guilty will be entered, and negotiation barred for same facts, and no appeal or review against rejection. So that is the detailed procedure of it. The reason why you must subject this plea agreement before the open court is that we have seen decision that if the court will not satisfy itself that the accused person acted voluntarily and was competent and understood the rights that are being waived, that is a ground on its own to challenge that plea agreement. It is a mandatory procedure for us to undertake. That is the rider when it comes to the outlining of the procedure for plea bargaining under the Kenyan law. And before you, we have the various section. If you read section 137 all the way, 137A up to 137M, it gives the detailed procedure on how that agreement is to be entered into. Then you should know that there are some sections, there are some offenses that will not allow for plea bargaining. What offenses are unsuitable for plea bargaining? Offenses are unsuitable where a plea agreement will undermine public interest or justice, and extreme violence, terrorism, serious sexual offenses, organized crime, and in particular, the Sexual Offences Act has categorically stated that you cannot use plea bargain agreements when it comes to this act. That is a direct interpretation of one of the sections in Sexual Offences Act. Explain, atrophies, acquit. This is a special plea that the accused has previously been acquitted of the same offense on the same facts. Therefore, it bars a second trial. This is what we call double jeopardy. In subordinate courts, the same concept appears in the plea stage under section 2075. Then we are told to explain the atrophies convict principle. A special plea that the accused has previously been convicted of the same offense on the same facts. It bars a second prosecution for that offense. But there are some exceptions. If there is a fact that has been discovered, but at the time of your conviction, it was not able to have been discovered, that is an exception that you will still face prosecution. Then, how does a presidential pardon affect criminal proceedings? A presidential pardon is pleaded as a bar to further proceedings on that offense. If pleaded and denied, the court tries whether it is true, If not proved, the accused must plead to the charge or information. Can accused person change a plea after conviction? And the answer is yes, but only in limited situations. The conviction on a guilty plea will stand unless the plea was equivocal or irregular. Only on misunderstanding, improper procedure, facts not supporting charge. Otherwise, the main post-conviction route is appeal, but it is very and often restricted or revision where appropriate. So you can change a plea after conviction, but in limited situations. Only where the plea was equivocal or irregular. Conviction on a guilty plea can be set aside where plea-taking record is defective, language was not recorded, consequences were not explained, and facts were not admitted. That is where the guilty plea can be set aside. Topic number 8 on bail and bond. Explain the constitutional right to bail. This is where an arrested person has the right to be released on bail and bond on reasonable conditions pending a charge or trial unless there are compelling reasons to deny release. What are the compelling reasons for denying bail? Compelling reasons were extensively discussed by Victor, and these will include being a flight risk, interference with witnesses, security of the accused person in his own capacity, and threats to public order or public interest and national security. There are some case laws to support that position, and witness intimidation and threats can be compelling. Flight risk shown by conduct is compelling, and safety of the accused and family threats can justify denial. Differentiate between police bond and court bail. A police bond is the administrative release by the police, being the officer in charge, while investigations or charging are ongoing and conditions to secure appearance will be set. On the other hand, the court bail or bond is the judicial release ordered by a court after first appearance or during proceedings with enforceable conditions and surety supervision. Police station officer or court power to admit to bail and bond without sureties is provided under section 123 of the CPC, while for the bond and bail structure and conditions, it is provided under section 124. What is an anticipatory bail? An anticipatory bail is a protective order sought before arrest or detention to prevent threatened unlawful arrest or violation of liberty, typically pursued as a constitutional relief. And to get anticipatory bail, you must prove a real, credible, and imminent threat of unlawful arrest or detention or other constitutional rights violation, not mere fear of arrest, and the court will balance that against the state's mandate to investigate and prosecute. Therefore, I saw it fit to draft various tests and even a template on how you will approach court for an anticipatory bail. What are the tests to satisfy? Test number 1 is that you have credible apprehension of imminent arrest or detention and threatened violation of rights. This is where you must place before the court cogent, specific evidence where you have summons, threats, prior conduct, OB references, phone messages, and even letters showing an actual or imminent threat to liberty or rights, not being speculative in nature. Test number 2 is where we have a prima facie constitutional case plus need to preserve the subject, where you also seek do not arrest and detain conservatory orders. You show a prima facie rights threat and prejudice if orders are not granted. This prejudice can be shown by unlawful detention, harassment, and coercion. Courts will protect liberty but will not stop lawful investigation. This was seen in the case of Kimgo and another versus DPP 2023. Then we have the last test, test number C. Courts will not use anticipatory bail to block lawful investigations. You must accept, and the court will usually order, that you will present yourself for interview and that investigations may continue lawfully. How will you draft an application when you are faced with facts that require you to draft one? The Republic of Kenya and the High Court of Kenya, which division? Constitution and Human Rights, constitutional petition number this, with a notice of motion application. Why are you attaching a notice of motion application? Because you will also be seeking interim orders, conservatory orders, pursuant to test number 2. Prima facie rights are being threatened, and there is a likely a prejudice that you will suffer unlawful detention and harassment. So you will be seeking interim orders, known as conservatory orders. Then those are the parties that you will incorporate: the DPP, the DCI, Inspector General, National Police, and the OCS if you know the relevant police station. Notice of motion under certificate of urgency being brought under Article 22, 23, 29, 49, and 165 of the Constitution and all enabling provisions of the law. Take notice that the petitioner or applicant shall move this honorable court for orders that this application be certified urgent and heard ex parte in the first instance, that pending the hearing of this application inter partes, this honorable court be pleased to grant a conservatory order restraining the respondents, their officers, agents, or any person acting under the authority from arresting, detaining, or otherwise unlawfully interfering with the applicant's liberty. That pending the hearing and determination of the petition, you are proposing to be admitted to anticipatory bail and bond in the sum of this amount, and that you are willing to present yourself for interview or upon service of written summons and shall cooperate with the investigations. And when you tell the examiner that the orders that you are seeking pursuant to the test, then the examiner will know that you duly understand the procedures. And then, why is it fatal for you to approach a court for an anticipatory bail with a notice of motion on its own? Remember, an anticipatory bail is not provided under an express provision of the law. An anticipatory bail is a constitutional relief in its nature. So failure to start with a petition, then you attach the notice of motion application, it will be fatal. We have seen decision declining, applications being brought without a constitutional petition attached thereto. So that is a rider that the examiner will test you on. The applicant, so these are the grounds, and the grounds are emanating from the various states that the decisions have bring forth. The applicant has received summons because you must show the imminent arrest. Mere apprehension is not justifiable. That the respondent conduct has created a real and demonstrable threat to the applicant's constitutional rights, including the right to liberty and security of the person. Maybe they even texted you. Unless conservatory orders and anticipatory bail are granted, the applicant stands to suffer irreparable prejudice through arbitrary arrest, detention, and harassment. The applicant is ready to attend investigation. This is the collaborating element that is coming along. And the balance of convenience and public interest favor protection of rights while allowing lawful investigations to proceed. You are not telling the court to interfere. And in the supporting affidavit, you attach the necessary evidence to support your application and petition. Explain bail pending appeal. This was tested in the 2026 criminal litigation paper, and the various tests that you should apply for you to be granted a bail pending appeal. A bail pending appeal is released after conviction while an appeal is still pending. It is not automatic. The applicant must show high chances of success or exceptional or special circumstances. You approach court via filing a notice of motion or chamber summons in some stations, seeking bail and bond pending appeal under CPC section 356 and 357, and it is supported by an affidavit and a draft memorandum or petition of appeal showing overwhelming chances of success and or exceptional circumstances. To win bail pending appeal, you must prove the following. The appeal has overwhelming chances of success or a substantial point of law likely to result in the appeal succeeding. And 2, exceptionally or unusual circumstances, plus show there is no practical reason to keep the convict in custody while the appeal is pending. So there are some statutory provisions to this application. We have section 357 of the Criminal Procedure Code that says you can admit appellant to bail, where you can even suspend sentence after appeal is entered. Then we have section 356 of the CPC. We have the bail or stay pending entering of an appeal. What are the tests that you must satisfy pursuant to an analysis? Test number 1, overwhelming chances of success and substantial point of law. What will the court look for? The court will look for a prominent or obvious error on the face of the record likely to make the conviction or sentence unsafe, not just arguable grounds. And the court normally wants the lower court proceedings or judgment to assess this. Bare grounds of appeal are often insufficient. How do you prove it? Your next judgment or type proceedings and draft petition or memorandum of appeal. So students who answered that question without annexing a memorandum of appeal to show that they have met the overwhelming chances of success in the appeal, the examiner failed them. Because that is a key and elementary test. Test number 2 is that you must prove exceptional or unusual circumstances. What qualifies here is that medical conditions only if you show treatment is unavailable or insufficient in prison or locally. Mere illness is not enough. Sentence is short and there is a real risk that the applicant will serve a substantial part or all before the appeal is heard. A delay in hearing the appeal may support the application when combined with other factors, not usually by itself. So those are the exceptional or unusual circumstances that the examiner will be expecting to hear from you. So if you are a student and you just cite that the client is ill, that is not a practical reason. Then you have test number 3 is the practical overlay, where we have post-conviction presumption. What the court will assume here is that after conviction or presumption of innocence is gone, the conviction stands unless set aside, so release is rare and discretionary. So basically, you should focus on test number 1 and test number 2 because test number 3 is laying the practical foundation of it and it is relying on a presumption of innocence. How will you draft this application? You approach court through a notice of motion, bail, or bond pending appeal. This is what the examiner was expecting the student to draft. The Republic of Kenya and the High Court of Kenya Act, this criminal appeal number or intended appeal, this number were filed under section 356. You give out the parties, notice of motion being brought under section 356 and 357 of the Criminal Procedure Code and all enabling provisions of the law. The contents are that this honorable court be pleased to admit the appellant or applicant to bail or bond pending the hearing and determination of his or her appeal against conviction and sentence from this matter. That in the alternative, this honorable court be pleased to suspend the execution of the sentence pending the hearing and determination of the appeal. Because we have seen pursuant to section 356, the High Court can suspend execution of the sentence pending the hearing and determination of the appeal. What are the grounds that the examiner will be looking at? This application is made on the following grounds. The applicant was convicted on this date and given this sentence. The applicant has lodged or intends to launch an appeal, and same raises substantial points of law with overwhelming chances of success, including ground number 1, there is defective charge, identification, confession, contradiction, and misdirection. Release the grounds. There exist exceptional and unusual circumstances justifying the release, namely, short sentence likely to be substantially served before appeal is heard, serious medical condition with evidence of unavailability of adequate prison treatment, and any other exceptional factor. So a student who captured their grounds to what exactly the law has provided scored the full marks. That is why criminal litigation paper has started recording low marks, because students rely on notes as compared to the statutory provisions. Then in the supporting affidavit, this is why you annex even a draft memorandum of appeal to show that you have high chances of success when this appeal of yours is being determined. So that is it. Explain the verification of sureties. This is anchored in section 124 of the CPC. Surety verification is the court's process to confirm a surety is real, traceable, financially capable, and not overcommitted, and understands the obligations before approving release. What happens when a surety wishes to withdraw? A surety may apply to be discharged, and the court issues a warrant to bring the accused on appearance or surrender. The bond is discharged as to that surety, and the accused must provide fresh sureties or be remanded. But they will give you a timeline for you to look for an alternative. Explain forfeiture of recognizance. If recognizance or bail bond conditions are breached, the court records proof of forfeiture, calls upon the bond person, surety to pay or show cause, and may recover by attachment or sale. In default, imprisonment may follow up to 6 months and court may remit part. What conditions may be imposed on bail? Attendance in court and mentions, reporting to police station, non-contact orders, travel restrictions or surrender a passport, residence conditions, curfew, cash bail and bond amounts, and sureties. Draft an oral application for bail. This is very important because this question can also be tested on your feet before the panel and also in the trial advocacy unit. This is how you will structure it. Your Honor, I am Victor, appearing on behalf of the accused person. I apply for the accused to be released on bail, on bond or bail on reasonable terms under the Constitution and the Criminal Procedure Code. The accused has a fixed abode at this place, is employed at this place and undertakes to attend court whenever required. There is no evidence of flight risk or interference of witnesses known. The accused will not contact them. We are ready to comply with any reporting condition, and we propose a bond of this amount or of like sum or cash bail of this amount and any further conditions the court deems fit. That is how you'll make your oral application. If the state alleges compelling reasons, we request they be supported by affidavit material and we be given a chance to respond. That marks the close of your opening and closing statements in regards to drafting an oral application for bail. Topic number 9, pre-trial conference. What is the purpose of pre-trial conference? Is to narrow issues, confirm disclosure, agree admissions, schedule witnesses and exhibits, and fix timelines so that the trial will run fairly and efficiently. What are the issues discussed during pre-trial? Whether full disclosure has been made, admissions and agreed facts and documents, witness management, exhibit management, and pending preliminary objections. Can parties agree on admissions before trial? And the answer is yes. Parties can agree to admit certain evidence and facts to shorten trial. This is provided under Section 20A of the Evidence Act. Proof of written statement by consent or agreed tendering and objection timelines. What if disclosure has not been made before trial? You move the court for the following: an order compelling disclosure and inspection, adjournment to cure prejudice, and or exclusion of late introduced material where fair trial will be undermined. How should counsel prepare a client before plea? You explain charge elements, possible sentences, plea options, and consequences of guilty plea or plea bargain. Confirm the language, understanding, ensure client knows the right to counsel, silence, and disclosure. If guilty contemplated, ensure facts actually support admission, avoid equivocal plea record. Topic 10 is about the trial process and stages of a criminal trial has repeatedly been discussed in this forum. Capcoris has gone to an extent of explaining the same over and over again, and this is a summary of it. We begin from the complaint being lodged, followed by arrest, followed by arraignment in court, followed by a charge where the plea is taken, prosecution case, and the prosecution case we have examination in chief, cross-examination, re-examination, close of prosecution, no case to answer ruling, defense case. Okay, let's say there is a case to answer ruling, then we go to defense case, we go to submissions, we go to judgment, we go to mitigation, we go to sentence, and the right of appeal. That is the full trial process. What is the purpose of an opening address? This is to outline the party intends to prove, identify key issues, witnesses, and orient the court, not evidence. Examination in chief versus cross-examination. Examination in chief, party calls witnesses to build its case. Generally, you ask non-leading questions. Then in cross-examination, opposing party tests credibility, accuracy, consistency, bias, and reliability. Leading questions are allowed because you are testing credibility, accuracy, consistency, bias, and reliability. While on the examination in chief, party calls witnesses to build its case. Cross-examining a hostile witness. What is the procedure that you will take? You seek leave to treat witness as hostile and then use leading questions, confront with prior inconsistent statements, narrow to a yes or no admission, and preserve record for submissions on credibility. What is the procedure for declaring a witness to be hostile? You make an oral application. You show the witness is adverse or contradicting prior statement or material facts, and court rules, then permit leading or cross by calling the party. This is where we will now combine with the above procedure on cross-examining a hostile witness. So you start with the procedure on making an oral application, then you seek leave to treat the witness as hostile. What is trial within a trial? This is a voir dire hearing to determine admissibility of contested evidence, classically confessions conducted separately so inadmissible material does not contaminate the main trial. Who may make a confession? When may a confession be admitted? Only if taken in strict compliance with the Evidence Act requirements, proper officer, not investigating officer, and third party of choice, or before a judge or magistrate, plus voluntariness. We have the confessions rules. Confessions generally inadmissible unless compliant with Section 25A of the Evidence Act. Submission of no case to answer. At close of prosecution case, defense may submit there is no prima facie case, and court must acquit if there is no evidence linking the accused to essential ingredients. What are the factors before placing accused on defense? Whether, if the accused elected to remain silent, the court could properly convict on the prosecution evidence, not a full merits decision. So basically, these are the point where we have started exhausting all possible questions in this unit. What are the defense options for an accused person? Good, this is a major one. Give sworn evidence. You have the option to give sworn evidence and you'll be subjected to cross-examination. You have the option to make an sworn statement. You have the right or option to remain silent and call no witnesses. And you have the option of calling defense witnesses and producing exhibits. So you have 4 in total. Sworn evidence and sworn statement, remain silent and call no witnesses, or you can call defense witnesses and produce exhibits. What is mitigation? Submissions after. What is mitigation? It comes submissions after conviction before sentence on personal circumstances and appropriate sentence. What are the factors influencing sentencing? We look at the nature and gravity of the offense, offender's role, harm, mitigation, aggravation, antecedents, victim impact statements, public interest, national security, proportionality, etc. What is a victim impact statement? A statement setting out physical, psychological, social, and or economic impact of the offense on the victim used to assist sentencing. What is the right of appeal after conviction? Accused may appeal conviction and or sentence under the appellate structure, where you move from the magistrate court to the High Court, then Court of Appeal, Supreme Court only on limited gateways. Prosecution seeks to amend the charge. What do? You object if amendment changes the case mid-trial unfairly. If the court allows amendment, insist on safeguards, where you want to take a fresh plea, you want to recall witnesses, and adjournment is misled in that situation. That is pursuant to Section 214. What happens if a key witness fails to attend? What do? You oppose to repeated adjournments. You insist prosecution demonstrate diligence and relevance. You push for the court to exercise control, either proceed and close prosecution or compel attendance if essential. If prosecution asks to call witness later, insist fair trial directions and timelines. That is pursuant to Section 205 of the CPC, where adjournment limits in subordinate courts, including custody implications. What happens when the prosecution introduces a new exhibit not previously discussed? What do? You object immediately because late disclosure violates the statutory disclosure regime and fair trial preparation. Seek orders for the exclusion and adjournment and full access for inspection and directions on chain of custody. This is provided under Section 42A of the CPC that makes it a mandatory disclosure plus reasonable access route. What happens when the client wishes to change plea? What do? If trial already commenced, treat as fresh plea request. Ensure the client is not pleading due to intimidation or surprise from late evidence. If guilt plea is contemplated, ensure plea is unequivocal. Demand charge and ingredients explained. Ensure facts are read and admitted, and record the language that has been used. Prosecution closes its case. What do? You make or reserve a no case to answer submission if prosecution evidence fails on essential ingredients. Emphasize that the court must only decide whether a prima facie case exists and not final guilt. The next batch will start from judgment and sentencing, and this will form the last part of this presentation because the preceding part after this one was on the appeal review procedure, and then you have special procedures. I had deliberately left them out because in the judicial bench book, we are to start from there and they are detailed in nature. So we have many applications. We have to draft a notice of appeal, memorandum of appeal, petition of appeal. We have to understand what are the key ingredients in each. You have to understand how do you approach court for a retrial. How do you move court from appealing from the magistrate court to the high court, from the high court to the court of appeal? Each stage has its own elements. Then for the special procedures, how do you approach various special courts, specialized courts? How do you approach the children's court? Because that is a matter arising in Kenya and we must revisit that with details and draftings involved. So I left that deliberately so that we can focus on the substantive part of which we have successfully completed. Then you can embark in another unit. So by the time the orals are coming, we have mastered the course outline to the details. We have extracted all possible procedures because it is also preparing us for the main examinations. And when we'll be having an analysis of the past paper questions with full force immediately after the orals, we will appreciate why some questions are being asked because we have seen the framework of the course outline. So generally in judgment and sentencing, it is not a detailed one because we must understand what constitutes a valid criminal judgment under the CPC. And a valid criminal judgment is one that is delivered, pronounced in open court and meets the mandatory contents requirement, where you have reissues, decision, reasons, date and signature, and on conviction, offense and section, and sentence on acquittal and offense and order of liberty. In April 2026 paper, the students were told to draft a ruling from a preliminary objection that had been raised. So a ruling will be testing on your ability to master various provisions of the Criminal Procedure Code, Penal Code, and to appreciate that you know the key ingredients that a ruling, if it is not signed, then it is not a ruling. A judgment, if it is not signed, then it is not a ruling. Students who had omitted that part lost a total of 5 marks because it shows that you don't really understand what constitute a valid judgment or ruling. What are the essential elements that every criminal judgment must contain? This is provided under section 169 of the CPC, where it is to be written by under direction of the presiding officer in language of court, points for determination, decision on each point, reasons for the decision, dated and signed by the presiding officer in open court at pronouncement. In additional mandatory specifics, we have if conviction, specify offense and section of the law, and if acquittal, state offense acquitted of and direct release. Then differentiate between conviction, acquittal, and discharge. A conviction is where we have a finding of guilt resulting in sentence or other lawful order must be reflected clearly in the judgment. Acquittal is a finding of not guilty where the judgment must state the offense and direct release, and discharge happens where termination without a conviction, often procedural, technical, or at an earlier stage, and may or may not bar re-prosecution depending on the type of discharge and context. Explain the purpose of a victim impact statement. This is to assist the court at sentencing by describing the physical, psychological, social, and economic impact of the offense on the victim, so sentence reflects harm and proportionality. At what stage is mitigation conducted? After conviction and before sentence is imposed. What factors should a court consider before imposing a sentence? Gravity of the offense, manner of commission, harm caused, role and capability of offender, aggravating and mitigating factors, prior record, antecedents and prospects of rehabilitation, victim impact, restitution, compensation where appropriate, proportionality and consistency. Explain the sentencing objective recognized by Kenyan courts. So common objectives, we have retribution, deterrence, rehabilitation, protection of the public, restoration, and denunciation and proportionality. Distinguish between concurrent and consecutive sentences. Concurrent means sentences run at the same time. You serve the longest. Consecutive means that sentences run one after the other. Aggregate time will increase. So that is the key difference. Concurrent, you serve the longest of them all. Consecutive, one after the other, one after the other. And the choice will depend on whether offenses arise from the same transaction, totality, and proportionality. Under what conditions may a court review or correct its sentence? Where a statute allows correction of an illegal, irregular sentence or correction of clerical slip errors, otherwise substantive alteration usually requires appeal or revision. Explain the accused rights of appeal after conviction. After conviction or sentence, an accused may appeal through the criminal appellate structure as provided by the statute. Scope depends on whether the conviction followed a full trial or a guilty plea, and on the level of the court. So that marks the end of the oral questions extracted directly from a criminal litigation paper. So we will embark later on the remainder of the various procedures to be discussed from this unit. Then we will marry the procedural elements on special courts to the same. So we will do an analysis of another course outline tomorrow so that we have a detailed approach to every unit. And I will be doing one for conveyancing because conveyancing also has many procedures and many potential questions to be asked during orals. So thank you so much, Albert, for your attendance. Let me end the recording unless you have a comment to make. How are these questions impacting you? Are they sufficient to what the examiner will be looking at? So thank you so much.